of the appellant, Mr. Taneja.
Taneja?
The appellee is Dr. Soraya.
Soraya. Okay. I made that a lot harder than it was. I think I added a syllable. And my apologies for that. And Mr. Canigliaro, you can start when you're ready.
Thank you. May it please the court. My name is Matt Canigliaro. I'm with Carlton Fields, and I'm here today on behalf of the appellant, as we said, Mr. Taneja. If I could reserve 4 minutes for rebuttal.
All right.
I'd like to start just with a really quick, big picture mention of sort of what's going on here. We've appealed really either the dismissal or the grant of summary judgment on 4 claims in the 4th amended complaint. One of them, count 4, was the fraudulent inducement claim. It concerns an option agreement, and it's really sort of distinct from the other 3. The other 3 that are at issue are count 2, which was a breach of fiduciary duty claim limited to the lack of consent for some transactions that happened. And then there were 2 other counts, count 6, which was a constructive fraud count, which involves breach of fiduciary duty as well, but it was more broad than count 2. And then count 7, which was an intentional breach of fiduciary duty count, along with a breach of contract count. So just having painted that picture a little bit, I'd like to, I guess if I have the opportunity, just begin with count 4. It's brief last in the briefing, but in preparing for the argument, it seemed to me maybe the most useful way to tackle these 4 was to address that one first, and hopefully a bit quickly, and then spend the rest of my time on the other 3 counts. So beginning with count 4, it was a count for fraudulent inducement. The trial court granted summary judgment on it based on the provision in what's referred to as an indemnification agreement that was signed 3 weeks after the parties all entered the main underlying agreements. That argument is not really embraced much in the answer brief. The answer brief has a series of other arguments that are raised instead. And I want to try to quickly talk about them. They've argued that there was no duty to disclose, as we point out in the reply. First, that's not the issue the judge ruled on. Second, that wasn't even raised in the opposition or in the motion for summary judgment, I'm sorry. And had it been raised, we would have addressed it in detail. There was reference to duty there, but it was an argument that there wasn't a duty under the permitted transfers provision of one of the agreements. And so in the end, if duty to disclose were an issue, and it shouldn't be here, but if it were, the simple answer would be that Florida law is clear that even in an arm's length transaction, when parties begin to speak to each other, they have a duty to disclose all material facts. Here, Dr. Soraya left out the option agreement he had entered with the Lowanis. And that was a significant matter, especially to Mr. Taneja. It may help to mention at the outset of all this, I don't think it would be missed by the court. All of the individuals who are involved here are part of a community, and they had social relationships. Some of them had business relationships. Trust is a major factor here. And the simple truth was what Dr. Soraya did in going behind Mr. Taneja's back with that option agreement was a violation of the trust that then existed. And had that been disclosed, really none of this would have happened, or at least there would have been a different deal that had been reached. Also, the answer brief argues a series of other things that are really fact issues, such as materiality or reliance. And then there's an issue about the statute of limitations. Again, all things the trial court did not rule on in granting summary judgment. The limitations argument basically says that because Mr. Taneja knew that a transfer had happened afterwards, back in 2007 or so, that triggered the running of the statute of limitations. As we point out in the briefs, as I'm sure the trial court understood, that doesn't hold water. We didn't know, there's no argument that Mr. Taneja knew about the option agreement, which is really the non-disclosure here, the fraudulent inducement. In a nutshell, those are the arguments regarding the fraudulent inducement count. The summary judgment on that count should be reversed. It was entered on an improper basis, and counsel admirably tries to find other reasons to support it, and none of them in the end hold up. I'll turn now to the other 3 counts, which are all centered somewhere around breach of fiduciary duty. And I'll begin with the first count addressed in the briefing, which is count 6. Count 6 was a constructive fraud count. The trial court dismissed it on a ground that wasn't raised in the motion to dismiss. The trial court dismissed it for failure to state a claim because the court misread the claim. The court was looking for non-disclosures and didn't appreciate that it was a constructive fraud claim based on a breach of fiduciary duty by Soraya. And so the trial court's rationale isn't even defended in the answer brief. So when the court begins to analyze court count 6, the only real question is there another basis in the record to affirm a dismissal of count 6? And the answer is no, there isn't. Soraya argues really two things. First, a collateral estoppel argument based on a summary judgment that was entered on a count we have not appealed, which is count 9. And then second, this derivative direct distinction. I'll begin first with the collateral estoppel argument. And collateral estoppel really comes in two flavors over the course of the briefing here. This is the first flavor. The first flavor is that because we didn't appeal the summary judgment on count 9, we're somehow precluded from raising error in count 6. That just doesn't work legally or factually here. Count 9, the trial court read it as dealing with leases, or the lease that was on the property, the real property, and that it was at too low of a rate below market and all the claims related to that. The court allowed that claim to go forward against Soraya based on a supposed breach of the subordination and standstill agreements. Soraya moved for summary judgment saying I wasn't a party to those agreements, and not surprisingly, he got summary judgment on that basis. None of that has anything to do with what's going on in count 6 with respect to Dr. Soraya. So the collateral estoppel argument does not work. And then we turn to the direct versus derivative arguments. This is a little bit of an unusual case in that there were only 2 members in this limited liability company, and one of them was the manager. And the events at issue are fairly extraordinary in what happened. And this claim alleges both direct harms and special injuries. And there's no dispute that within the case law, a claim can be direct if you have direct harm and special injury, or if you have a statute or a contract that allows you a right to sue. Here, the case law is clear that a manager owes statutory duties to members of an LLC, and the operating agreement that's at issue, the contract here, that included language about when the managing member could make these certain extraordinary decisions, has an express provision in it. And I wish in the reply brief I just quoted the whole thing. I would direct the court to page 2295 of the record. The Exculpation Clause states the manager shall not be liable to any member for good faith actions or failures to act. This is all concerning the unanimous consent provision. Then the next sentence says, such persons shall be liable for their gross negligence or for their own willful misconduct in the performance of their obligations under this agreement. That language is crystal clear that there could be a contractual claim brought. So all this, and the trial court understood that, at least at one point in this case, in referencing the contract as a basis why the claims here were direct and not derivative. So for all of those reasons, count 6 should not have been dismissed for failure to state a claim, and there isn't an alternative sort of tipsy coachman basis to do so. At this point, I want to speak for just a moment about what's going on with these fiduciary duty claims. A few different things are really at issue. One is that Soraya violated the operating agreement by not getting unanimous consent for these extraordinary actions that took place in 2012 with this grand settlement. That's one. If we didn't have that provision in the agreement for unanimous consent, there would still be a breach of fiduciary duty claim on the same actions, because what he did was still so extraordinary, it was arguably a breach of fiduciary duty. That's an easy argument for us to make. And then beyond that, beyond the breach of fiduciary duty with regard to disposing of downtown St. Pete properties assets, beyond the lack of unanimous consent, there was still this set of events that occurred in that grand settlement in 2012 that were beyond extraordinary and extraordinarily harmful to Mr. Tenasia's interest. The managing member of downtown St. Pete properties, wearing that hat, entered an agreement with the bank and with a company that Soraya created, that's FSFA, and with others, but those were the principal folks, to do extraordinary things. They agreed to sell, well, basically to give away the assets of the company to the bank.
Well, discuss that for a second. I mean, if I read throughout your brief where you're talking about the giveaway of this, but they had pledged this asset, correct?
Yes, Your Honor.
So under what circumstance would a manager of the LLC be able to keep that asset? How is he going to keep it? I mean, other than maybe for some limited period of time, there was already litigation starting. So just expound on that a little bit as to how your theory would allow them to have kept this asset and done something with it if it was 100% pledged to someone else. So then he used that. And I guess your argument is that parlayed into a benefit for him.
These are, argument in the end is very simple, that this was one grand settlement and it involved many parts. Had the only thing that happened was that the assets of the company were turned over, had that been the only thing that happened, this would be arguably a very different case. But it's not the only thing that happened. These all happened together. As FSFA was created, Soraya arranged for this transfer to the bank and then for the bank to transfer those assets to FSFA. There were the agreements with Abed and with Paragon, which got Dr. Soraya off the hook. They released the standstill agreements that were protecting Soraya and Tunesia from execution on those other loans, the Abed loan and the Paragon loan. And Soraya got kickbacks from the amounts that would be recovered by Abed and Paragon. Those are personal kickbacks. It's hard to picture sort of a grander breach of trust and fiduciary duty for a manager than what happened in this package. And so respectfully, Your Honor, it would be incorrect to simply isolate the documents and them being given away. This has to be looked at as a package. And it was a package. That's what happened. It was a grand.
I was only
settlement.
responding to you. I mean, you said they got rid of the assets, and that basically was the asset, correct? At that point,
The loan documents concerning the $4.8 million loan. Yes, Your Honor.
Okay.
And so these things can't be sliced up in isolation. It was a package. And if we only focused on the Abed and Paragon deals, which were basically, not only was it self-serving for Soraya, but it was incredibly damaging for Mr. Tunesia, because wearing his hat as manager of Downtown St. Pete Properties, Soraya released the standstill agreements. That was part of the package. And so that now those lawsuits went forward against Mr. Tunesia. I mean, that's, in the end, an extraordinary set of circumstances. It absolutely amounts to a breach of fiduciary duty. And remember, count 6 went out on failure to state a claim for not having language about concealing things or whatnot. The court just misread the claim. There is not a direct derivative problem here. And if I turn to count 7, really, we have a similar situation. Count 7 was dismissed by the court based on the direct derivative arguments. Count 7 was a claim for intentional breach of fiduciary duty and for breach of contract. The breach of contract being the operating agreement provisions that required unanimous consent, and the fiduciary duty claims being the items I was just discussing, and with really some extra provisions as well, including excluding Mr. Tunesia from the settlement discussions at the mediation. This whole deal was made without him. Had he been part of this, it would have been very different. Maybe none of this would ever have happened in terms of this litigation. But we have what we have. Count 7 is a claim for breach of intentional breach of fiduciary duty, and also for breach of contract. The answer brief doesn't want to start with this direct derivative distinction. The answer brief wants to start with collateral estoppel. This collateral estoppel is different than the sort of first flavor I mentioned before. This one concerns the earlier appeal. when Mr. Tunesia lost the case against the attorneys in the law firm that were previously involved as defendants, there was an appeal in that case. This court PCA'd the appeal. We appreciate that. The briefing has been provided to this court, and collateral estoppel does not work here. The only argument that was made in the law firm appeal regarding this count 7, was that there couldn't have been a standing problem because downtown St. Pete properties had been dissolved. It's the only argument that was raised in the count 7 appeal there. And so, as we explained in the briefs as well, we don't have identity of parties. We don't have identity of issues for the reason I just said. And arguably, this is not something that should be raised on appeal for the first time in any event. But for all those reasons, there's not collateral estoppel. The other appeal involved the law firm and the claims against the law firm in count 7. These are the claims against Soraya. And then we have the argument that was successful with the trial court there, that this was, I say successful, the court granted a motion to dismiss. All it said was granted. So we assume the court did so for the reasons that were in the motion. The reason that was in the motion was that this was a derivative claim, not a direct claim. But for the reasons I said before, that just doesn't work. I think at one point the court appreciated that under the operating agreement, there was clearly language that the members could bring a suit for intentional misconduct. And that's exactly what we have here, intentional misconduct. And then beyond that, there are the statutory duties. There's the direct harm to Mr. Tunesia. This is so far removed from the situation where there's just a number of shareholders in a company or a number of members in a limited liability company, and somebody just wants to sue because in their capacity as a shareholder, their shares lost value. That is not this at all.
All right, sir, that was pretty good. You're right at 16 minutes.
Well, I've left one count out, so if I could just speak briefly so that—
You may use your time however you like, sir.
I appreciate that, Your Honor. On count 2, I do not want to leave it out. It was an extremely important claim. This was breach of fiduciary duty, really limited to the withholding of or not obtaining unanimous consent. This is the argument with the trial court entering summary judgment based on these 4 grounds. 3 of them were never even argued. They, by my view, are abandoned in the answer brief. The arguments that are made in the answer brief are collateral estoppel, which fails for the reasons I mentioned earlier. These issues were not argued in the prior appeal. That was an appeal against the law firm. And then the second is involving the loan documents. They stand on the loan documents argument. But as we explained in the reply brief, the loan documents didn't authorize this. It just would be a complete misreading of them to think that they do. Yes, there was a resolution that dealt with making arrangements with the bank, but not breaching your fiduciary duties with the bank, and not an agreement that also covered other parties, such as FSFA in this case. The other provisions just don't even begin to cover this. This was, the arguments get made that, well, the bank could have demanded these things. The bank could have stepped into the shoes of downtown St. Pete. Well, but it didn't. It didn't do those things. This was a settlement. The settlement was a breach. And if I can save the balance of my time for rebuttal, I'd appreciate it.
You can. Thank you. Mr. Carey?
Thank you, Your Honor. May it please the court, Michael Carey for Dr. Soraya. I will start with count 4 as Mr. Conigliaro did. I agree with him that count 4 arises at a different point in time than the other counts. It was actually a couple of years earlier at the inception of the relationship. Count 4 is a claim for fraudulent inducement. Mr. Tunesia claims that he was fraudulently induced to sign some guarantees in favor of lenders. The alleged inducement is a single act of non-disclosure, and that is an option agreement which Dr. Soraya and his company, Suburban Federal, had to acquire an additional interest in fuel investment development, which we refer to as FID2 or FID2, and is only entitled to recover that in the event certain events occurred. The trial court granted summary judgment on count 4, and it should be affirmed for 2 reasons. First, the fatal defect in count 4 is that the FID2 operating agreement expressly allowed transfers between members without notice to and without consent of the other members. Therefore, there was no duty to disclose something that they were allowed to do without notice and without consent. Likewise, it wouldn't be reasonable to rely upon that not happening if it's expressly allowed. And it's also not material, as we argued in our brief. The bottom line here is that Mr. or Dr. Soraya could have gotten the option the day before, the day after, or the day of the signing the loan guarantees. It really didn't matter. That was something that was expressly allowed that Mr. Tanasia agreed to when he signed the FID 2 operating agreement. We also request that count 4 be affirmed on the basis of statute of limitations. Tanasia admits he was aware of the transfer of this interest in October or November of 2007, which is more than 4 years before filing suit, and therefore the statute of limitation clearly applies. I'd like to briefly address Mr. Coniglio's argument that the trial judge didn't rule on those grounds. He ruled on some other grounds. If you look at the order of the trial court, it is very clear he was granting the motion on the grounds raised. Then he went on and says that one argument Tanasia's counsel made was that count 4 was supported by a joint and several indemnity agreement. The judge goes on to address that. That is not the sole basis for the court's ruling. It's quite clear he was granting it on the grounds that we raised. It is unfair and unfounded criticism of the trial judge to say that he got that one wrong, or he ruled on the wrong grounds. So for those reasons, we would respectfully request that count 4 be granted. I'd like to next address count 2, and that is a breach of fiduciary duty claim. The factual basis for count 2 is in paragraph 40 of the Second Amendment complaint, and that is the disposal of all DSPP's property and assets. Now, at the outset, I should mention it's a misnomer to say there's a disposal of assets, because what happened is the bank repossessed the assets, which they had the absolute right to do under the loan documents that Mr. Tanasia signed and agreed to. Not only did they have the right to do it, but Mr. Tanasia and Dr. Soraya had the absolute obligation to surrender the collateral upon default. And we're talking about a maturity default here. The note had matured that DSPP owed to the bank. So the trial court properly granted summary judgment. We'd request affirmance on 2 grounds. One is consent and authorization by Tanasia. Tanasia personally signed the loan documents. The loan documents required the surrender of collateral upon default, which is what happened. Moreover, there was a resolution that Mr. Tanasia agreed to when he signed the final notice of final agreement. That resolution expressly authorized Dr. Soraya to enter in agreements of any nature with the bank and would be binding upon downtown St. Pete properties. Tanasia's counsel on record before the trial court admitted that the loan documents gave the bank the right to do whatever they wanted to do without asking anybody. And that's a direct point.
Do you have the record site for that handy?
Yes, I believe that is 2852.
Thank you.
So bottom line here is that Soraya's surrendering of the collateral upon demand was not only authorized, but was required on the loan documents. We'd also request affirmance of count 2 on the basis of collateral estoppel or issue preclusion. This exact same count was brought against McFarland Ferguson and Mr. Lennon. Matter of fact, at the argument on the summary judgment, I made the argument and they just said, me too, literally. And the trial court affirmed, the trial court granted summary judgment, this court affirmed. So we're talking about the same count, the same identical claim. We got privies in terms of lawyers, and so we have all requirements of collateral estoppel are present. So we respectfully request that count 2 be affirmed. And finally, we have counts 6 and 7. And count 6 is a claim for fraud. And Mr. Conigliaro tries to recast it in his brief, but if you look at it, particularly paragraph 116, the pleader was attempting to plead a claim for fraud. Then you have count 7, which is a claim for damages. There's no theory identified. I would agree with Mr. Conigliaro, it's probably meant to be a breach of fiduciary duty and breach of contract combined. But in any event, I'd like to address those together because you have a lot of the same factual allegations in both counts. In both counts, the trial court granted a motion to dismiss with prejudice of the Fourth Amendment complaint. And finally, both counts allege derivative claims. So I'd like to, there's two grounds we would urge for affirmance. The first is that both counts allege derivative claims in a direct action, which is not allowed under Florida law. Now, this was a recurring issue before the trial court. We had two separate court orders directing Tenasia to maintain his direct and his derivative claims in separate actions. The 2013 was the direct case. The 2015 was the derivative case. There was a special litigation committee appointed to hear or to make recommendations with respect to the derivative case. Tenasia failed and refused to comply with the court order. He insisted on including derivative claims in the 2013 direct case, and then counts 6 and 7 are prime examples of that. And Mr. Tenasia had very experienced trial counsel at the trial court level. And there's no question what they were trying to do was get a second bite at the apple. And as proof that counts 6 and 7 are derivative, if you look at the derivative case, you will see the Third Amendment complaint in the derivative case, the one that went to the Special Litigation Committee. There are virtually identical counts to count 6 and 7 of this case. Specifically, count 8 of the derivative lawsuit is virtually identical to count 6 of this case. And count 3 of the derivative lawsuit is virtually identical to count 7 of this case. If you look at some of the substantive allegations of count 6 and 7, you'll see that they allege derivative claims. Both count 6 and 7 allege disposition of DSPP's assets as a basis for the claims being alleged. It's hard to imagine a clear example of a derivative action, and when you're talking about action involving assets of an entity. Under the De Niro case, which both parties have briefed, a pleader is required to allege a direct claim. They must allege direct harm and also special injury. In connection with the disposition of assets, any alleged injury would be to the entity DSPP. Any alleged injury to Tenasia would be indirect or derivative. Count 6 and 7, another example. Count 6 and 7 both allege the alleged waiver or release of junior lenders from subordination and settlement agreement. That's alleged in both counts. There's no allegation in either count of direct harm or special injury to Tenasia arising out of that. There are two reported decisions of this court from 2012, authored by Judge Altenburn, dealing with these exact same subordination settlement agreements. And those cases held that the subordination standstill agreements did not preclude the junior lenders, Abed and Horizon, from suing or obtaining judgment against the guarantors, including Mr. Tenasia. They only affected the priority of collection rights between the senior and junior lenders. They did not affect or increase any liability of Tenasia. And that is why Tenasia, in his pleadings, can't identify any special injury or direct harm to himself, because there is none. Now, Mr. Canigos has argued today, and he argued in his brief, that counts 6 and 7 fit within an exception to De Niro for statutory or contractual claims. We would respectfully disagree. First of all, there are no statutory claims pled. Second, to fit within the exception to De Niro for contractual claims, those contractual claims must arise out of an operating agreement which contains a provision stating that members shall be directly liable to each other for breaches of the terms of the operating agreement. That's right out of De Niro. And if you look at the operating agreement in this case, the DSPP agreement has no such provision. There's no such provision stating that members shall be directly liable to each other. If you look at the operating agreement language that is quoted in De Niro from that case, much stronger than the language in the DSPP operating agreement. The court in De Niro held did not fit within the exception. So we'd respectfully request that counts 6 and 7 be dismissed based upon the fact that they improperly assert derivative claims. The second grounds for affirmance for count 6 and 7 is collateral estoppel or issue preclusion. We have 3 different reasons. First, in count 7 was an action brought as a derivative action, both against Soraya, but also against McFarland Ferguson and Patrick Lennon. That dismissal was affirmed by the court, this court, on appeal. McFarland Ferguson and Lennon are privies of Soraya as his attorneys. Therefore, you have identity of parties for purpose of collateral estoppel, and all other elements of collateral estoppel are present. There are also allegations in both counts concerning waiver and release of subordination standstill agreements, as I mentioned before. The trial court granted summary judgment on count 9, which was specifically on that. It was not appealed, therefore we have a final decision. Therefore, Tenacia should be collaterally stopped from asserting the claims he's asserting here, which are really at the pleading stage regarding the waiver and release of subordination standstill agreement, where the court's granted summary judgment saying there's no basis for a claim. And finally, we have in count 6 and 7, we have the allegations of disposition of DSPP assets. The trial court granted summary judgment on count 2. We'd respectfully suggest that this court should affirm that. It's on appeal before you. And if affirmed, that should collaterally stop Tenacia from asserting further claims regarding the disposition of DSPP's assets. Finally, I'd like to address a few of the replies which Tenacia made regarding collateral estoppel. First, he argues that collateral estoppel is an affirmative defense which must be pled. The flaw with that argument is that the final judgment and the appellate decisions that we are relying upon that form the basis of collateral estoppel in this case were not entered until after the dismissal of count 6 and 7. Therefore, they could not have been pled as affirmative defenses. Second, Mr. Tenacia argues that collateral estoppel requires a prior suit, not the same action. As a general rule, there usually is a prior suit. In the case, that's what the courts are referring to. But collateral estoppel is also known as estoppel by judgment. A judgment can constitute collateral estoppel, whether it is in the normal case where you have multiple lawsuits, or in the fairly unusual case we hear where you have separate judgments all arising out of the same action. The last thing that Mr. Tenacia argues in reply is there's no identity of issues, and he specifically refers to count 6, which Mr. Conigliaro has tried to recast as a claim for constructive fraud, was been pled as a claim for fraud, and count 9, which he claims is a claim for breach of contract. However, if you break that down, you will see that count 6, as I mentioned, is pled as a fraud count. Count 9 was initially pled as fraud and breach of contract. The trial court dismissed the fraud portion of that complaint with prejudice. It was never appealed. Summary judgment was granted on the breach of contract. So we do have an identity of issues between them, between the two counts. So for all those reasons, we respectfully request that all 4 counts at issue in this appeal be affirmed. Thank you.
Thank you, sir. All right.
Your Honor,
Rebuttal?
Thank you, Your Honor.
You have like 4 minutes left, which is
I
I think
appreciate
what you
that.
wanted. Yeah.
I understand that there's a sort of a philosophy and practice of if you just throw enough at a court, it becomes hard for the court to resist at some point just throwing up its hands. And this is a case where a lot has been basically placed in the court's hands. We would encourage the court to try to work through these, because in the end, and I guess maybe I'll start with this as a big picture point. In the end, it should be as simple as this. Mr. Tenacia was a member of an LLC. The managing member sold him out, not just by turning over the documents. Your Honor raised a point about that earlier. And had all that happened was the LLC turned over the loan documents because the bank demanded them, or had the bank said, we're going to step into your shoes, LLC, and we're going to vote and have these outcomes, then I'd say we wouldn't be here today. That's not what happened. What happened was the documents were held back until there was a grand settlement. And that grand settlement had all these parts, and the parts included waiving the standstill agreements, releasing everyone involved except Mr. Tanasia, and basically creating these kickback situations where Dr. Soraya was going to get kickbacks when Abed and Paragon recovered from Mr. Tanasia. That alone must be actionable somewhere in the law. So if we bring our claims, they say, oh, these are really derivative claims. What happened with the derivative claims? No, there's no claim here. That's what happened with the derivative claims. And so how could there not be an action for something so improper as managing member wearing your hat to release those standstill agreements? Counsel just argued, well, the standstill agreements really didn't stop collection. They adjusted priority, and there was no reason for Abed and Paragon to go forward knowing they weren't going to get the money. And so that's how that played out. The court at this point should be looking at the actual events. What did the bank do or not do? What did Abed and Paragon do or not do? All these things should be taken in the light most favorable to Mr. Tanasia. And under these circumstances, I respectfully suggest there must be a claim. You can't, as the manager, make these steps and basically betray your only other member, and have no claim as a matter of law against you. There's just no claim. That can't be. These claims for breach of fiduciary duty absolutely have merit. And now I'll go through a little bit more detail at this point. First, regarding count 4, counsel mentioned, well, that the transfer provision allowed for transfer, so there couldn't have been fraudulent inducement. The trial court never said that, and it's just wrong. First of all, the option agreement here was also with Soraya. And so there wasn't an opportunity under the transfer provision to transfer it to Dr. Soraya. And second of all, the point is this fact, the agreement here, this option agreement was withheld. Had it not been withheld, these things wouldn't have happened. And we can't look to later events to say, well, it doesn't matter. I know I'm about out of time. With regard to the other claims, I want to emphasize that the claims were broadly pled, and they involved different arguments against different defendants within the claims. The other claims against the law firm were not the claims that were against Dr. Soraya. And with regard to the agreement, counsel said that there is nothing in the operating agreement. I want to direct the court, page 2295 of the record, section 4.4 of the operating agreement makes absolutely clear that these could be direct claims. Such persons shall be liable for their own willful misconduct in the performance of their obligations. The prior sentence says the manager shall not be liable to any member for good faith actions. That allowed these claims to be brought directly. These are not derivative claims. If the court has any questions, I'm happy to answer them.
I have one question. I'm doing something I always try not to do, which is ask it when time's up. But I feel like I read somewhere in your brief that these counts at issue, even though this is like the 4th amended complaint, these counts hadn't been amended previously. This is the first time they were, like, at least the motion to dismiss was directed to one of these counts. Is that right?
In essence, yes, Your Honor. There was a strange set of circumstances in how
was there any request for leave to amend, or is there anything? Were you trying to get at that when you mentioned that fact in your brief?
No, I think what we were trying to do was to explain that that sometimes there's a sense of momentum, like you've tried and you've tried and you've tried, and that's just not what happened.
And that's not the case with these counts. Okay, I appreciate that, and I want to thank you both for these well-presented arguments. This is a thorny case factually, and I personally appreciate the efforts that you made during oral argument and in your briefing to help us digest all this. Thank you.
Thank you, Your Honor.
All right, our next case on this morning's docket is our last case, Moran and Andrews